Ms. Spears is here today after failing to appear before this court on November 1st, 2023. Bond is currently set at $1,419. This is the sixth bench warrant. Front of the court is unaware of any current employment. Last payment made on this case was on November 15th of 2023. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on December 27th, 2023 at 8:45 a.m. before this court.
Ms. Spears, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on December 27, 2023 at 8:45 a.m. Are you able to post a bond, ma'am?
The only amount of money that I have is in my personal effects, and that's like $50.
Are you currently working?
I just got a job at Riverside Country Club. I was actually supposed to be there today to fill out pre-employment paperwork.
Well, what I'm going to do is I am going to reduce your bond in hopes that you could be out of jail. What I'm going to do, I'm going to reduce your bond. I'm going to reduce it to $100. If you're able to post that, you'll be able to be released. Do you have any questions?
Nope, no question, Your Honor.
2023.
Okay, thank you. You have a good day.
Thank you, you too.
Good morning to both of you.
Good morning, Your Honor.
Good morning.
Court will note that this matter is before the court on the plaintiff's motion to show cause in this matter. The defendant has filed a response, and the court has reviewed that. Ms. Sanford, anything else you'd like to add other than in your motion?
No, Your Honor. I think the court has benefit of all of the paperwork, and since you've reviewed that, no.
Okay. And sir, do you have anything else in addition to and other than your motion or your answer?
Well, Judge, I just to ask if the court received my supplemental answer to her reply.
Yes, we did.
Judge, I would just indicate that back in 2018, 2018, we were trying to determine the credits that I was entitled to and when she was going to make arrangements to refinance the house, and she walked away from that process, and I haven't heard anything for 4 years. Okay. And now apparently she believes that that she doesn't have a duty to comply with the terms of the judgment because my debt was somehow discharged in bankruptcy. But I attached to the court that this was on my credit report till the middle of 2022, and apparently a new mortgage company bought the note. I don't know how else they would get access to it, so there must still be a note. And as I've always indicated, I always paid this mortgage outside of the bankruptcy plan, so I don't understand the issue.
Okay. Well, obviously the court notes in reviewing the pleadings that there are various disputes in the case, and court feels we're going to have an evidentiary hearing to ferret out what's happened. I will tell both of you that the court will simply enforce the judgment of divorce and the orders that have already been entered in this matter. I won't attempt to interpret the judgment or the orders. I'm simply going to enforce those. I note a defendant had raised some issues about monies owed for groceries or something of that nature, states that there is no need. I'm not going to get into the need or all that. I'm just going to get into what do the orders and the judgment state, and then we'll get compliance with that. So we'll get in touch with both of you and see when you're available, and we'll set an evidentiary hearing, and we'll get the matter concluded.
Thank you, Your Honor.
Okay.
Thank you.
Thank you. We'll be in touch in the next couple of days. Good morning to everyone.
Good morning.
Good morning.
Court will note the appearance of Mr. Schaefer on behalf of the plaintiff, Ms. Elaine on behalf of the defendant. The matter is before the court on the plaintiff's motion to show cause. I note in reviewing the answer, Mr. Schaefer, that Ms. Elaine had stated that, in fact, that the arrearage in this case had been paid off. Have you were able to confirm that?
It was paid off as of November 24th. We confirmed that it got paid off on that particular date.
Okay, so that's a moot point at this time.
I think so, Your Honor, yes.
Okay. What we'll do in this matter, I do note as well that Ms. Elaine had brought up the issue of the counseling, and again, that had happened years ago in this particular matter. It's my understanding that that may be a moot point as well. Have there been any new attempts at counseling since this court was involved, Mr. Schaefer?
I don't believe so, Your Honor. There have not been, I mean, there's a tortured history of that back when, and we have gone back on so many different things on support and parenting time, and we still have parenting time and custody pending, and another show cause in relation to the parenting time. And this was all amalgamated together back when, and during the testimony, it is clear that, and admittedly so, that there was a violation of the order of joint custody, and that is why we are bringing it at this point in time, just because it's an ongoing, from our perspective, an ongoing harassment that needs to be held in check, and I think it needs to be reviewed.
Well, this court had obviously had a hearing in this matter, quite extensive hearing that we concluded with an order of September 25, 2023. I will let the parties know I'm not going to go into any other matters that predate that order of September 25, 2023. So if in fact the court would allow a evidentiary hearing, because we have a lot of other claims I guess floating around, but I'm not going to go back prior to the September 25, 2023. So I'm only going to take up matters at an evidentiary hearing that post-date that particular order. So we will contact both of you and see when you're available and when we can set up hearing to resolve the other, I guess, pending claims in this matter. But so both of you know I'm not going back to anything prior to that September 25 order.
Your Honor, to my knowledge, there aren't any other pending matters that aren't currently scheduled. Do you have a different understanding?
No, I just know that we've had so many motions filed and so many other things. I just want to make clear that I'm not going to go back prior to that date. So if that resolves everything else that we have, then we won't need an evidentiary hearing. So, but I'll leave that up to the two of you.
Okay. I think that's a fair analysis. I think everything else is scheduled, Your Honor.
Okay. Okay.
Your Honor, if I may, especially based on opposing counsel's responses to your questions today, I do think this is appropriate for an attorney fee award for the reasons stated in our motion. I think it can't be more clear that Ms. Tabaka is doing this as a retaliatory measure, and Mr. Schaefer today is not offering any legal argument to support the allegations that were brought. And I do think the court should put a stop to that and send a message that it's not going to entertain its judicial position to hear retaliatory motions brought years after an alleged event occurred.
Well, I don't know.
I'll be happy to respond, Your Honor. There's a lot more to this, and I'll be happy to. But based on your ruling, I think it should be done at this point in time. But I'll be happy to deal with the retaliatory question as it relates to the other side.
Okay, well, what happens is, why don't we do this, is it appears that there are no outstanding disputes in this matter, other than, as Mr. Lane brings up, the attorney fee issue. So what we'll do is I will, I guess, leave it open that any of the parties, if they have anything that post dates the September 25, 23 order, they can file a motion, and then we'll take that up at that time and have an evidentiary hearing if we need, but I guess I'll put this matter to rest at this point. Okay?
Thank you, Your Honor.
Thank you. Thank you all. We'll end this matter at 9:06 a.m. You're free to go. Have a good day. Good morning to everyone. The court will note that the appearance of Ms. Smith on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for change in custody. Ms. Smith. You're muted, ma'am. You have to unmute.
Sorry, Your Honor. Yes, we are asking that an evidentiary hearing be had or that a temporary order be put in place Based on the current circumstances after the last custody hearing, there has been verbal and emotional abuse by Mr. Monroy towards both Miss Columbia and the minor in question. There's also been threats, and Mr. Monroy has withheld the child from Miss Columbia during her parenting time. He recently withheld the child from her during the Thanksgiving holiday and has threatened to withhold the child from her during the Christmas holiday. We also have reason to believe that his home is overcrowded with children sleeping at the top of the stairs and with the relatives sleeping in the laundry room. So the living environment is not particularly fit for a child. The child has also expressed issues with depression and thought based on kind of the environment and the living situation in Mr. Monroe's home. So we are requesting an evidentiary hearing to change what the current custody order is, and also a temporary order that would move the minor child to Miss Columbia until an evidentiary hearing is scheduled.
Okay, well, I'll tell you so that you know, for your edification, the court does not change custody on a temporary basis without an evidentiary hearing. So there'll be no temporary orders issued to that effect. Mr. Monroy, do you have a response or?
Oh, yes, Your Honor.
Okay,
Recently in October, I had CPS come out to the house to okay it for my 2 young grandkids that were being taken by the state of Virginia. So I have currently them in my home due to CPS saying that it was more than enough of a livable area for them. My aunt has been staying here off and on. She's very sick. She has some lung issues, so she hasn't had her own place in some years, and the person she was living with died. So I let her come to my house till she can find a place, but she's my dad's blood sister, and like I said, she lives on oxygen, so I hate to see anything happen to her. But she's been in and out of the house. She doesn't just stay here, but she stays at several places wherever they let her in, and I try to let her in because I hate to see anything happen to her. But outside of that, I work every day, doing the same thing. A lot of the argumentative basis of the paperwork that was sent was the same thing she argued with last time: the forging, the supposedly, CPS, the assaults or the battery. My daughter has never expressed to me not one time that she was suicidal, and I talked to her all the time. And when I talked to her about this situation, when I found out about it, she said she never said it. But that's secondhand news. But you could ask her yourself.
Okay. Well, the court does note that many things have been alleged in this case, and many things that have been alleged would meet the Vadvarka threshold of proper cause or change in circumstances, at least sufficient for an evidentiary hearing. I don't know if they'll, again, carry the day as it relates to an evidentiary hearing, but at least they rise to that level to meet that threshold. So the court will schedule the matter for an evidentiary hearing. And I will tell you that in the meantime, the court expects that the orders will be followed. So if there are parenting time that's scheduled under those particular judgments or orders, the court will enforce that. So I'll again assume and order that the parties comply with the current orders of the court. Yes.
I was going to say the problem is she's using court papers from March of last year instead of the ones from when you had your final order, I believe was in June.
We go from the final order though. So
right, but she's not using that paperwork. I got her a copy and she wouldn't take it.
Oh, that's her problem then.
That's what I said. So
if you're complying with the last order of the court, then that's all you have to do.
Thank you, Your Honor. That's what I am doing.
We'll contact the Ms. Smith, and Mr. Monroy will contact you and set a date for an evidentiary hearing in this matter. And but until then, just comply with the most recent order. Okay.
Thank you, Your Honor.
Thank you. Court will end this matter at 11 to everyone at 9.
Morning, Your Honor.
Good morning.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff, Mr. Toth on behalf of defendant. This matter is before the court on the plaintiff's motion for temporary custody, parenting time support to extend discovery and mediation. Mr. Toth has filed an answer. I have reviewed all of the pleadings in this matter. Anything else to add, Ms. McNiff?
Your Honor, I would just state that I don't believe that we have an agreement on the counselor. My client attempted counseling with a counselor that she chose, and Mr. Johnson didn't show at that counseling appointment that he chose a counselor. I think that we need a neutral counselor. I've talked to Mr. Toth about possibly going with Margaret Hunter in Kalamazoo because she does specialize in reunification counseling, and she's been getting these cases done in a very quick timeline. Mr. Toth wasn't crazy about that idea, but I do think we need somebody who has some experience with reunification counseling.
Okay.
That's the main issue. As far as discovery is concerned, if I could just have another 2 weeks to send some subpoenas out, that would be very helpful. I think then we could still maintain the mediation date. But there are some, I do have some bank account statements that Mr. Toth has sent to me, but there's some additional information that I would like to be able to get. As the court knows, I got in very, very late into this case, and so we're kind of up against the clock. But if I could have that additional time, I think I could get what I need in order to attend the mediation on the 25th. And then the last issue, really, we don't have any order with regard to custody and parenting time. I believe that we should have at least joint legal custody. My client should have at a minimum standard parenting time. Child support, Mr. Toth is asking that it be set back from the date of separation. Mr. Toth knows that we can't go retroactive on child support. However, my client does understand that she needs to support the children, and we would ask that support be commenced as of today's date.
Okay, thank you. Mr. Toth, why are you being unreasonable, not giving Ms. McNiff another two weeks for discovery?
Your Honor, if provided that we preserve our mediation date, I have no objection to discovery being extended for 14 days.
Okay.
So that would be number one. Number two, Your Honor, I have no objection to a temporary order for joint legal custody. And I would further concede that with joint legal custody, both parties need to agree or should agree on who's going to be doing the reunification therapy. So if the plaintiff does not agree with Suzanne Warren of continuing that process, then I would have no objection to it being administered by Margaret Hunter. Number three, child support, if it's going to be established, should certainly be retroactive to the date of the filing of the complaint. The minor children have been exclusively with my client, Your Honor. Your Honor, I think it would be further inappropriate to establish a temporary parenting time schedule until we have an opportunity to have a hearing. There's a terrific amount or a terrific disparity between the positions of the parties as to what's happening, and it would even go as far as to include where the plaintiff's living. My client believes that the client has been living in Bellevue with her boyfriend. The parties have been separated for 6 months, Your Honor, and there's been no overnight parenting time. It's only gotten more and more difficult. The relationship between the parties is not good. The relationship between the mother and the children is extraordinarily strained, Your Honor. And I believe that the oldest child is now 17 years of age. He's having a terrific struggle with this entire situation. So, Your Honor, I think it would be inappropriate to establish any type of a schedule until we've had a hearing. The status quo ought to be maintained. If the boys will go with their mother, great, but there's been no overnight, and this is the first time that this matter has been brought to the court's attention. The status quo should be maintained. Hopefully this issue can be ironed out at mediation, and my experience with Margaret Hunter is she's very adept at making recommendations for a phased-in reunification schedule, and I think it would be most appropriate if the court is going to enter an order that would identify that the schedule progress according to the recommendation of Margaret Hunter on a temporary basis.
Okay. Anything else, Ms. McNiff?
Your Honor, I would say that there should be some parenting time, even if it's not overnight, even if it's not, for a week at a time. There should be some. There's no indication that my client is abusive to the children or neglectful of the children. We could stipulate that she would have all parenting time without any romantic partner. She could have parenting time strictly at her sister's home, which would be an appropriate place to do that. It is the holidays. It would be reasonable for her to be able to see the children for some period of time.
Okay. Mr. Toth, do you have any issues with that if it's more limited and again, it's not in the home where her partner is there?
No, I think that would be appropriate, Your Honor. The concern that I would have is these boys simply are not prepared to go spend overnight time with their mother presently. It's taken 6 months to get here, and I don't think that in one day we're going to be able to change their attitude. And we're certainly not looking to set a situation up where my client's going to be in contempt of a court's order.
Okay. Well, what we'll do is in this matter is, again, it's been agreed upon a couple things that we would extend the discovery for an additional 2 weeks. So we'll do that. Also agreed that we'll utilize Margaret Hunter for the counseling. So that can be included in the order as well. There is agreement as to joint legal custody, and court will grant to the defendant physical custody in this matter. I am going to, as a result of the holidays, et cetera, I am going to provide plaintiff with some parenting time in this matter on basically on the alternating holidays, but that would be for a period of, again, 5 hours from 12 o'clock noon to 5 o'clock p.m. And that she would have alternating Saturdays for the same time from 12 noon to 5 o'clock p.m. until such time as Ms. Hunter can make a recommendation, and then we can evaluate it at that time. Court will, again, set support in place, but I'm not going to take it back to the retroactive to the date of the complaint. I'll take it to the date of notice of plaintiff's motion in this matter. So whatever date that you sent that out and had proof of service on, Ms. McNiff, add 5 days for notice, and then we'll take it from that date, and she'll be required to pay whatever the guidelines require.
Will do.
Anything else, Ms. McNiff?
No, sir.
Mr. Toth?
No, Your Honor.
Okay, thank you all. Do I need to designate who's going to get Christmas Eve and Christmas Day, or the alternate, or what?
The kids are in Florida right now, and I don't know if they're coming back prior to Christmas. My client may know.
Do you know, Mr. Toth?
I'm not certain, Your Honor. I can find out. What I can represent, Your Honor, is that I would hope that Ms. McNiff and I can, once we get what the schedule is, that we can work it out. And okay.
Well, attempt to do that. And I guess I'd say if the kids are gone and they weren't going to be back on Christmas Eve or Christmas Day, then what we could do is then give the plaintiff New Year's Eve and New Year's Day for the same 5 hours each day, and then alternate thereafter. But maybe you can come up with some sort of a better arrangement, then that would work as well.
Very good.
Thank
okay.
You, Your Honor.
Thank you,
Your Honor.
Court will note the appearance of Ms. McNiff on behalf of the plaintiffs and Ms. Podolsky on behalf of the defendant. This matter is before the court on the plaintiff's motion to enforce grandparenting visitation time. Ms. McNiff.
Your Honor, after reviewing Ms. Podolsky's answer, it seems that the parties are at extreme odds in terms of their perspective on this matter. And my thought is perhaps we do send everybody back to Suzanne Warren and then set up for an evidentiary hearing in order to sort out some of these issues where the parties are at extreme polar opposites.
Okay. Ms. Podolsky, what do you think about that proposal?
We have no issue sending the matter back to Susanna Warren. As the court's aware, that is what the current order says when there is a dispute. It's also what we requested. I don't believe an evidentiary hearing at this time would be necessary. These parties were perfectly capable working with Susanna in the past to craft this order, and I think they will be able to get through their issues, these current issues, and that's what my client's been trying to do. So I don't think an evidentiary hearing would be necessary, but absolutely a referral back to Susanna Warren.
Okay, the court will refer the matter back to Susanna Warren for additional, counseling and additional recommendation in this particular matter. I will, I guess, at that time state in the event that the parties are not in agreement with the recommendation, then they can file to seek a evidentiary hearing as to any disputed matters at that particular time. I will state at this point, until that happens, the court simply will enforce its orders, and those orders still remain in full force and effect. And then we will address that after Ms. Warren has an opportunity to reassess the case. Okay, Ms. McNiff, you can prepare that order to send the matter back.
Thank you, Your Honor.
Okay, thank you all. The court will end this matter at 9. The court will note the appearance of Ms. Reiser on behalf of the plaintiff, defendant appearing in pro per. This matter is before the court on the plaintiff's motion for change of legal custody modification of parenting time for the child to, again, attend therapy as well as appointment of a guardian ad litem. I will state before we commence, Ms. Reiser, I am acquainted with both of the parties in this particular matter. I don't anticipate, nor do I see that being an issue in the case, but I bring it up for a matter of record in the event that you wish to proceed and dispute my involvement in the case.
No, Your Honor. Ms. Jordan informed me that you are familiar with both of them.
Okay, that's fine. You can proceed with your motion.
Okay. Good morning, Your Honor. The parties have been divorced since 2015. They have two children together, one that remains a minor. He is 15. Dad has sole legal custody. They share physical custody. The current parenting time order was entered in about 6.5 years ago in 2017. According to that order, during the school year, mom has alternate weekends, Wednesdays after school until 8. She has week on, week off in the summer, alternate holidays and school breaks. Recently, while in dad's care, the child skipped school, walked in the snow to mom's house without her knowledge or consent, and he refused to return to dad's house. The police were called, CPS was called, the child still refused to return. CPS created a safety plan and told mom that the child should stay with her until they could investigate. Eventually, mom convinced the child that he had to go back to dad's, and he did, but there are still some concerns that he will run away. The child reports that he's not properly fed at dad's house. It's not that there's not food in the home, there is, but he says that he is not allowed to partake in family meals. He's giving small microwavable meals while the rest of the family eats in front of him. The child's been asking to go to the dentist for some time. He says he has a tooth that's decaying and he's in a lot of pain. Dad refuses to take him to the dentist. I thought maybe it was a financial concern, but I don't believe that's the case because dad himself goes to the dentist. The child reports that he's mentally and emotionally abused at dad's house. He says that he can dad will tell him, you saw what I did to your mother. I can do it to you too. I can make it so that you never see her again. He only he doesn't refer to my client by name or as your mom. He only refers to her as the cunt in front of the child, which is inappropriate. He's done things like he sprays Windex on the child's sunburn. When the child says it hurts, he said, that's the reaction I was looking for. The child reports he's not fed breakfast. He's not given blankets at night. Prior to the entry of the last order, the child was on psychiatric medication and he was attending therapy. He's been asking to go back to therapy. At the time he was 8, now he's 15. Dad won't allow him to go to therapy. It's my understanding that both parties suffer from mental health issues. Mom's compliant with her medication. She sees her daughter regularly. The child reports that dad says bipolar, which is what my understanding of what dad suffers from, is a made-up disease and medication's not required. Mom's asking for joint legal custody. She's asking that I recognize an evidentiary hearing needs to be held. I believe there's proper cause and change in circumstance. We're asking that an evidentiary hearing be scheduled to consider a change in legal custody so that mom can be involved in these important decision-making decisions for the child, medicine, dental decisions, educational decisions. She's also asking, considering that the child's threatening to run away, that a guardian ad litem be appointed to be the eyes and ears of the court so that we're ensured that his best interests are met. Or in the alternative, I would ask that you interview the child, which would be appropriate considering that his preference is one of the factors. I think it's factor I. We're asking that he immediately start therapy. She says anybody at Summit Place in Battle Creek is agreeable, and that he be able to go to the dentist. And she's asking for week on, week off parenting time throughout the school year as well until we can figure out what's going on here through the guardian ad litem.
Okay, thank you. Mr. Haley, what's your response?
Well, as far as a lot of the accusations, I'm going to say that they're false. So as for the dentist, I can tell you he's been to the dentist. He has a referral to U of M, which is scheduled in July. And I actually have the CPS record when they came and investigated recently. I also have concerns of the mother's home, even though the paperwork says CPS is okay. I'd recommend you calling the investigator and talking to the investigator too, seeing that the investigator said mom's house looks like it's cluttered and like almost a hoarding situation. as for the evidentiary hearing, I'm agreeable to one. And as far as therapy, I have him an appointment already set up for after the runaway to be seen. Medication was stopped back then due to age being so young, and he was on 5 medications, and he hasn't had really any issues. There's no abuse in my house, and I seen in the paperwork where it said I called for parental kidnapping. Mother failed to inform me that she had called CPS and there was a safety plan in place. So I do have some concerns with a 50-50 parental when she fails to even communicate with the littlest things, even when it comes to trying to do punishments in houses. When I would say Nico's grounded, she won't enforce it over there. She don't do anything. In the past, she took him to doctors without trying to talk and gets him on medication. So the 50-50, I'd recommend holding off for the parental, but she wants the physical part. I'm agreeable to let some of that happen, but CPS would be stepping in because they're concerned about her house.
Okay. Well,
And the investigator told me to call.
Okay. Why you state that he has a referral to U of M that's not until July? Why so long?
They have a backlog of people, and that was what they had. I just got a new job and new dental, and the other part that is I'm looking for an oral surgeon here. They have to do a root canal on that tooth to try to save it or to extract it. Okay. And Family Health Center or Grace Health in Battle Creek cannot extract the tooth from him.
Okay. Well, if you could, in the interim, try to get something. If you have new health insurance and new dental, to get him in before July, because that seems like an inordinate amount of time to delay.
I agree.
So try to get him in before that. And apparently, just all I'm going to do is say try to get him in. You can work on that and see what you come up with. Okay.
And then I got an appointment set up for a therapy interview coming up to get him into therapy. So that's one I will agree on. As far as
is that at Summit Point?
It's going to be they have me take him into a clinic here at Summit Point, and then we're going to go from there.
Okay. Well, the court will order that the child does receive again that referral, and then that the parties would continue with any therapy as recommended at that point. The court does note that based upon the allegations in the motion, and as stated here, that again, it does meet the Varka threshold for an evidentiary hearing on the issue of joint legal custody and parenting time. So the court what I'll do is I'll refer the matter to the referee for a hearing on those two particular issues. Court does not believe that there's a sufficient basis alleged or stated today that the court would appoint a guardian ad litem in this matter. The court, both myself and the referees, can make an independent assessment in this particular matter without the assistance of a guardian ad litem. So that will be the interim order of the court. I'm not changing anything until such time as we have that hearing. Ms. Reiser, you can prepare the order and submit under 7-day notice of entry.
Thank you, Your Honor.
Okay.
Would you like me to email you a copy or e-file? How would you like me to send you a copy of the 7-day?
Send it through the clerk's office. Everything has to go through the clerk. So just send it in, to the clerk's office, and then we'll get it through them.
Okay. Thank you, Your Honor. Have a happy holiday.
Thank you. We'll end this matter at 10:04 a.m. You're free to go. Have a good day.
Thank you.
Court will note the appearance of Mr. Todd on behalf of the plaintiff. This matter is before the court on the plaintiff's motion to set aside referee order. Mr. Todd.
Thank you, Your Honor. Your Honor, in this particular case, the court had a full-blown evidentiary hearing less than a year ago. Subsequently, Ms. Volker filed a motion hearing, which was heard November 22nd, alleging a request for a change in custody and parenting time. The only statement contained within that motion is that the child wants to spend more time, allegedly, with the defendant. There has not been good cause or change in circumstances. That alone is insufficient. The referee determined that there was, in essence, good cause to revisit parenting time, but not custody. We believe that this is in conflict with Vodbarka, in that this is, in essence, just trying to take another proverbial bite at the apple. So we are respectfully requesting that the order be set aside and the defendant's motion be dismissed in total, as it's our understanding that nothing has changed since the last court order.
Okay, thank you. Ms. Volker, what's your response?
Good morning, Your Honor. The reason I am taking Mr. Volker back to court is since the order was put in place in February, Mr. Volker has denied me to be able to see my daughter other than the one weekend a month.
Okay, ma'am, what we're doing is we're addressing just the referee hearing and the referee's order. I'm not going to go back and dredge up all the things that happened almost a year ago in this matter.
Well,
so
then I guess
they are seeking to set aside that order. Tell me why I shouldn't set aside the order.
Because I would like to be able to spend more time with my child, and my child would like to spend more time with me.
Okay. Well, Mr. Todd, I see that it does appear that the plaintiff is simply arguing Vodbarka, but the court does note that Shade v. Wright is the applicable law as it relates to parenting time. The motion hearing was for change in custody, parenting time, and other relief. And so the court does believe it's appropriate, if the referee believes that there was sufficient basis to proceed on parenting time, that would be appropriate as opposed to any change in custody. So the court doesn't see that there is a basis to set aside the referee order in this matter for evidentiary hearing as it relates to parenting time. I just note in this matter that it's not been established that there was a factual or legal error made by the referee. So the court is going to let it proceed on the issue of parenting time in this matter. So the court will deny the motion at this time.
Okay.
Okay, thank you. And court will end this matter at 10 a.m. Court will note the appearance of Ms. McIntyre on behalf of the defendant in this matter. Court will note that Ms. Capture, we've been in contact with her office. She does not intend to appear at this particular hearing. The matter is before the court on Ms. McIntyre's motion to withdraw in this matter. Ms. McIntyre.
Good morning, Your Honor. I have filed a motion to withdraw because while I really enjoyed representing Ms. Parr up until this point, I think that there has become a breakdown in the community, in a relationship between Ms. Parr and myself. And I would base that particularly on trust issues and also financial issues. And so therefore, I would ask that the court allow me to withdraw.
Okay. Ms. Parr, what's your response to the motion?
Since the hearing is only postponed for over a year and ending up consent order same as usual, I work at factory, just try to save my kid.
Okay, ma'am, please address yourself to the motion. I don't want to get into all of those other issues. She's filed a motion to withdraw. That's what we're addressing today.
Yeah, I don't mind to withdraw, and I would like to refund at least a couple thousand of my money that has not been spending on the case, so I can hire a new attorney.
Okay, so you're not opposed to her withdrawing, correct?
No, Your Honor, that's her choice.
Okay.
I cannot force her not to, but I would like to return a couple thousand of my money.
Well, I'm not going to address that. That's not before the court. And the court will grant the motion to withdraw. Ms. McIntyre, you can submit an order allowing the withdrawal, and that will complete the matter. We'll end this hearing at 10:15 a.m. You're free to go. Have a good day.
Thank you. You too. Good luck, Parr. Ms. Parr.
Court will note the appearance of Mr. Todd on behalf of the defendant. This matter is before the court on Mr. Todd's objection to the proposed order. Mr. Todd.
Thank you, Your Honor. Your Honor, the order submitted did not reflect accurately the court's order. The order in paragraph 6 indicates parties' parenting time schedule shall revert back to the previous alternating weeks. That was never ordered. And so the only modification contained within our proposed order is in fact removing that. So we are respectfully requesting the alternative order we submitted be entered.
Okay, thank you. Mr. McMaster, you've heard the objection. What's your response?
My response is I do feel that the 7-day order, that as it was written, does in fact represent what was ordered. Both the defendant and I are in agreement with the changes that needed to occur, and we have both agreed to follow Meredith's recommendations, which would not be possible if the weeks are not switched back to the original order. In the exhibit that I submitted,
Sure, let me tell you.
Sure.
Regardless of what you agree, you can agree to anything you want to agree, but you can't agree and say, well, this is the reason I included a provision that wasn't ordered.
Yes,
the
sir.
order would have to reflect what the court ruled. If
Yes,
you have
sir.
something else, you can do an order modifying that by agreement of the parties, but you can't do it under the guise, if you would, that the court had ordered something that I didn't order.
Yes, sir. I understand that, but when you had ordered it, you ordered us to follow Meredith's plan, and we had both agreed to follow Meredith's plan. In the exhibit, I submitted a statement provided from Meredith outlining the importance and necessity for the weeks to revert back to the original schedule and allow for reintegration to occur. It's my belief that their argument is it's a moot point. It is implied in paragraph 12, section E, that this must occur in order for the minor children to live together. It is also part of Meredith's overall plan for reintegration. The order needed to be clear and concise to avoid disputes or possibly requiring additional motions to progress the reintegration process. I would also like to point out that the order, as it was written, is under the guidance and supervision of Meredith Katz, and as such, the weeks can only return to normal pending Meredith's approval.
What you've been telling me is you've talked about inferences, you've talked about what needs to be done, you haven't talked about what the court ruled. And right. Mr. Todd is arguing I did not rule that the parties' parenting time schedule revert to the previous alteration of weeks as they were prior to the December order. Okay. And if I didn't rule on that, then it won't be in the new order. You can change it subsequently if you have agreement, but I can't simply put it in because you say, well, that's the way it should be, or, you know, because Ms. Katz is, again, making recommendations, it needs to be that way. It's what did the court rule, and that's what needs to be in the order.
Yes, sir. I understand that. I think there
sounds like you're acknowledging, no, the court didn't rule that way, but we needed to have it in there to carry out the intent of the other orders.
Well, because the way it was ordered, you said to follow paragraph 12 from the motion. In paragraph 12, section E, it does outline that the minor children will live together. That is part of Meredith's plan for this, is to get the weeks back to normal so that the minor children can live together. Unfortunately, in paragraph 12, which is what you had pointed out as what we would follow for the order, it wasn't very clear. And in order for clarification, we had to have something in there. Otherwise, there's just no ability to follow up or follow through with paragraph 12. We don't have the ability to have the kids together because we're switching weeks in order to separate the children. If we can't have the kids together, we cannot have the kids reintegrate.
I understand what you're saying, sir, but the issue is what is the court's ruling in this matter. We can't simply after the fact say, well, this is what it should have been, not disputing that it may have should have been that way, but it wasn't the ruling at that time. Mr. Todd, what's your response?
Your Honor, there was no testimony from Ms. Katz. There were no exhibits. I believe that the order we submitted is in fact accurate. If there is dispute about, you know, how to actually follow Meredith's recommendations, I believe she would be the appropriate party. The parties are currently in counseling. The order we submitted, I believe, will allow the parties to do all of that.
Okay. Well, what the court's going to do is the court is going to, again, implement the court's ruling in this matter, which the court does believe consistent with Mr. Todd's order. Mr. McMaster, all I can say is that if there needs to be further modification to carry out Ms. Katz's, I guess, recommendation, then you'll have to file a motion to that effect, and then we can address it at that time.
Okay. Can I ask one question, sir?
Sure. You can ask any question you want. It doesn't mean we'll answer it, but you can ask it.
Is now the order as it was written through Mr. Todd Is that now in full force and effect as of today?
It will be when it's signed, and I assume it'll be signed today, but I don't know that for a fact.
Okay.
But it should be. I mean, typically after these hearings, they'll send me the order and I'll get them signed at that particular point. But you know, I can't say that there wouldn't be a glitch or something of that nature, but it'd be unusual that it wouldn't be signed today.
And if Mayor, which again, to respond to Mr. Todd, I did submit an exhibit, and I did attach a proof of service. I sent it to both his office and I submitted it to the court as well. But my point of that is Mayor did point out the fact that she does think that for the reintegration process to be completed, we have to go back to the original weeks. Is this something that Christine and I, the defendant and I, can work out with Mayor, or is this something we're going to have to return to court with?
You can work it out with Mayor, then make sure that it gets reflected in an order so that we have an order to that effect. And
Absolutely.
I'll let you know, Mr. McMaster, just so you know, because this happens sometimes when there's therapy or counseling, is they'll say, well, the counselor said this or the counselor recommended this. The court follows the court orders, and recommendations or what the counselor says does not modify or amend a court order. All it is at that point is a recommendation. And until it gets put into an order, it has no more effect than your neighbor talking to you or anything like that. So if the two of you can agree after speaking to Ms. Katz, great, do an order up, we'll get it entered, and then that will take care of the matter. Okay?
All right. Thank you.
Court will end this matter at 10:24 a.m. You're free to go. Have a good day. Court will note the appearance of Mr. Robinson on behalf of the plaintiff, the defendant appearing in pro per. I don't know if you heard that, Mr. Robinson, that front of the court had approved a different judgment in this matter order, but not the one that you had noticed up for entry.
Yes, Your Honor. The judgment is the same. The objection was to the uniform child support order.
Okay.
There was a scrivener's error in the case number. Instead of being DC, it said DE. That was changed. And then in the paragraph where it talks about the annual ordinary medical expenses for the child, I hadn't put per year per child because it says it's an annual expense and there's only one child. So I had to add the per child per year.
Okay. Have you submitted that so you've got approval now, Mr. Robinson?
Yes.
Okay.
I do have final approval, and I believe Friday we sent, and I think we emailed the final approved.
Okay. We'll check it. We'll check and see in that. Ms. Heights, do you have any response to the notice of entry? You're muted, ma'am.
I actually, Tyler just messaged me about 10 minutes ago that I had this court case. I wasn't exactly aware of it.
Okay.
But I mean, we've both agreed that we support Gracie very well together without a court order. So.
Okay. Well, what to do is if the court will check, and if we do have the front of the court approval in the file, we will enter the judgment as submitted by Mr. Robinson. That will conclude the matter. Anything else, Mr. Robinson?
No, Your Honor, except I will tell you that the uniform child support order sets Ms. Heights' support at $0 per month. After the hearing, my client informed me that he had gotten a very big raise and was making like $84,000 a year, and he thought that was more than enough to support himself and their daughter. And Ms. Heights works part-time as a waitress and has 2 other kids to support, and he said he didn't want to take money away from them.
Okay, well, that's fine, and apparently he can forgive support if he wishes to do so, as long as he's not getting public assistance. But again, that's fine, and as long as we got the approval, we'll get the order entered. Anything else, Ms. Heights?
No, Your Honor.
Okay, thank you all. We'll court will end this matter at 10:28 a.m. You're free to go. Have a good day.
Thank you
as well.
At 10:32 a.m.
Thanks.
Court will note the appearance of Mr. Kelly on behalf of the plaintiff, Ms. Bruno on behalf of defendant. This matter is before the court on the plaintiff counsel's motion to withdraw. Mr. Kelly.
Your Honor, simply put, and
compliance with the motion that we filed, there's been a breakdown of the attorney-client relationship, or we simply cannot adequately represent Ms. Avery moving forward, and we'd request a withdrawal. Thank you.
Okay. Ms. Bruno, what's your response? Do you oppose the motion or what?
We do not oppose the motion.
Okay. Ms. Ratliff, you're muted. You can take yourself off muting. Would you like to say anything?
No.
Okay, yes.
Yes. Oh, no, I have, the only thing I got to say is I've just been trying to come up with the money. My husband's on disability. We didn't know when we started this case that he got hurt. And since September, he's been off of work, only bringing $350 home a week. So we've just been trying to come up with a solution to try to pay Mr. Kelly. And I understand why he wants to, but the only reason I haven't signed the release was because I was trying to come up with the money.
Okay. Well, the court will grant the motion. Now, Mr. Kelly, did you include an order with that, or do you have to submit an order?
We'll submit an order, Your Honor.
You submit under 7-day notice of entry, and that will conclude this matter at 10:34 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
Thank you.
Good morning to both of you. Court will note that the parties are both appearing in pro per. This matter is before the court on the plaintiff's motion to set aside referee recommended order. Ms. Bird, you had stated in your motion, I do not agree with the referee's decision for visitation and child support arrangement. I will tell you, you don't need to agree to that. If you are, again, challenging the referee's determination, you have to demonstrate that the referee made a factual or legal error. And I would note you have not alleged any, so I'll give you this opportunity to, again, address that issue.
Well, we had court on November 13th. And I didn't get my court papers in the mail until November 17th is the only reason why I didn't show up. Because I didn't know about it. So that's why I appealed it.
Okay.
That was pretty much the issue.
Okay. Well, if again, if there was improper service in this matter, you have a right to file a motion to contest the entry of the order on improper service. You haven't done that. You simply challenged it saying you don't agree with it. That doesn't give the court any notice, nor does it give the defendant any notice as to what you're disputing. So a court doesn't believe that the motion filed to set aside the referee recommendation is appropriate in this matter. Again, you can file whatever other motion you wish if, again, there was not proper service, etc. But I don't think the way that you filed is appropriate. So the court is going to deny your request at this time. So that will conclude the matter at 10:37 a.m.
McIntosh
free to
versus
go.
Erica McIntosh, Attorney Podolsky for defendant.
Good afternoon. How are you this afternoon?
Good. How are you, Judge?
Good. Mr. McIntosh, in this particular matter, just so you are aware, what this is a scheduling conference whereby the court puts into place various procedures and time deadlines so that the matter will proceed in an orderly fashion. What I'm going to do is ask you first, because you're the plaintiff, then I'll turn to Ms. Podolsky for input. So first, I'd like to find out what issues, sir, do you believe there to be in dispute in the case?
He's on mute.
You need to unmute your device, sir.
I believe that the joint physical custody is what is in dispute at this time.
Okay, so custody is in dispute. Okay. Any other issues in dispute that you're aware of?
None that I'm aware of.
Okay. Ms. Podolsky, what's your position?
I would agree. Custody, parenting time, child support. The parties do have property and debt that also needs to be divided. We've not had any initial conversations yet. So I think those boxes should at least be checked for now.
Okay. And are you in need of discovery in this matter?
I would say if we could have till the end of February.
Okay. Mr. McIntosh, what happens is for discovery, that's the process whereby you can find out information from the other side. And you can do that through interrogatories, requests for production of documents, depositions, or any other means that would be available to you under the court rules. So, but you have to do that. I'm going to put March 1 as the deadline. You'll have to do that by March 1. You understand that, sir?
Yes, sir.
Okay. And that way, it'll progress at that point. I will set mediation for March. Sir, do you have anyone you'd recommend as a mediator in this matter?
I have no recommendations.
Okay. Ms. Podolsky, any recommendations?
John Brundage.
Okay. Mr. McIntosh, do you have any problem with Mr. Brundage serving as the mediator?
I don't believe so.
Okay. Just so you're aware, he does handle about 80% of all the mediations in the county. So he has very substantial and successful experience at this. If he's not able to, Ms. Podolsky, who is an alternate?
Lisa McNiff.
Do you have a problem with Ms. McNiff serving as an alternate, sir?
I don't believe so.
Okay. Well, chances are that Mr. Brundage will be able to. We just always put it down in the event that there is a problem that we'll have a backup at that point. We'll set April 8th as the settlement conference date. Sir, parties are required to be present. It'll be by Zoom, but you're required to be present unless we've come to a full agreement prior to that time. It'll be set for 1:30 p.m. And then we will, again, see what issues remain at that point and then progress at that time. Anything else, sir, that you have before we conclude?
Not at this time.
Okay. Ms. Podolsky?
Nothing, thank you.
Okay, thank you, sir. You're going to get that in probably a little less than a week, the scheduling order. Make sure you pay attention to the dates because there are dates that documents and stuff have to be exchanged and provided. And if you don't do that, it could have ramifications in your case, okay?
All right. Thank you, sir.
Thank you. You're free to go. Have a good day.
1:28 p.m.
Thank you. Have a nice day.
Attorney Joseph Vanderhorst is filling in for Jonathan Vanderhorst and Attorney Glazer for defendant.
Okay, thank you.
Good afternoon.
Mr. Vanderhorst, no filling in, okay?
Well, last week I had another one for John because he's been sick. The referee thought I was John's brother.
That's only because he dyes his hair, Your Honor.
That makes you feel good, doesn't it?
Yeah, it makes me feel good. I told John that he didn't feel too good about it.
No, I can imagine. He started feeling bad then.
Well, I said to the referee, I think you need she had glasses. I think you need stronger glasses.
Yes. Yeah, that's fine.
anyway, but hey, one second, Your Honor. I haven't seen old Matt in a long time. Hey, Matt, how you doing?
Good, and yourself?
Good. You're gonna duke it with my son, huh?
Well, I talked. I don't think there's a lot of duking on this case. I just got filled in a little more by your son. Apparently, there's a bankruptcy involved with this, and
all
kinds of stuff. So I'm not.
Yeah.
I told the defendant that come in and I'll help him iron it all out, and we'll get it worked out. But.
Okay. Well, what are the issues that you believe or that appear to be in dispute?
Well, they got. Can I pipe in, Matt? I kind of got a brief by John. They got two kids, two daughters. I guess the marital home has been sold. I guess is going to close relatively soon, as maybe as early as Friday, Matt.
Right.
The closing. My client lives with her parents in Plainwell.
Right.
She moved out not too long ago. The kids are with her. So I think the issues probably are going to be custody, the typical ones there. I guess the bankruptcy is going to kind of, I think it's a 13, man. I don't think it's a 7.
Yeah, I don't know. I just, the husband stopped in briefly and I said, fine, bring it in. I knew John was on the other side.
Yeah, I think it's a 13. So that's overlaying it, but, it's bankruptcy, of course, the division of the whatever's left in the house. Right. I don't know if she's got retirement accounts. I don't think he's done a lot of work in Matt, to be honest.
Actually, I thought they drained. Well, we'll get into it, but
I think if we need mediation, just hire Brundage.
Yeah, I would say Brundage if we need mediation. If we can't work it out before that.
Okay. I'll put down that property's an issue only because we don't know what's going to happen in the bankruptcy.
Correct.
Yeah.
And if you give us 60 days discovery, Your Honor, can you do that?
Yeah, we can.
I'm just trying to push it out a little, so John and I or if he has to bring in his own man for support, one of us will try to figure it out. But I'm sure the bankruptcy is the only crippling thing.
Yeah,
we'll put the discovery deadline as March 1. That'll give you sufficient time.
Yep.
And who would you like as the mediator?
Brundage, Your Honor.
Brundage is fine.
Okay.
And I don't know who they got other than him for backup. So
I think McNiff, is it, or
Lisa's fine,
or Podolsky? I don't.
I would go with Lisa. I think
Lisa. Okay.
Yeah. I don't know. Miss Podolsky. She was always a young snot-nosed attorney when I was there, so I don't know.
Well, I'll tell her that you said that she was young. I'm sure she's not young anymore. I won't add in the rest of that though, Mr.
Lisa's at least been around the same blocks that we have.
Well, Your Honor, just quick. Usually I see Matt on my client owes like $50,000 in child support. You're still doing that stuff too, Attorney General? And
No. I'm right now. I'm the Branch County Public Defender, at least I think until August or September, and then I'm getting out of here, and then I'm going to come back. No, I'm going to move back into my office a little bit, but I don't know if I'm going to come back into a full swing or not.
Okay. Well, you're jumping around and making us guess, Mr. Glacier.
That's right.
So when did you give up the Attorney General gig?
I gave that up years ago. Well, when I came down here, I told the county I would hire in down here and open up their office, but as soon as I got it running, I'm out of here. It's running fine, so I'm going to take my leave come, I think it's August or September, somewhere around there.
Oh, good for you though, Matt.
Yep.
Okay, well, we'll get this out to you, and I put in April 8th as the settlement conference date, 1:30 p.m. You'll get it. It's in the scheduling order, so that will provide you with all the dates and everything else. So,
all right.
Perfect. Thanks,
anything else, Mr. Vanderhorst?
No, Your Honor.
Mr. Glacier?
Nothing further, Your Honor. Thank you.
Okay, thank you. You guys have a good day.
Yeah,
and,
thank you, Judge. Hey, thanks, Matt.
Yeah, no problem. See you, Joe.
4 p.m.
Bye.
Attorney Michael Kelly for defendant.
Okay. Good afternoon to everyone.
Good afternoon.
I'll go to you first, Ms. Meska, as you're the plaintiff. Tell me what's happening in the case.
Mr. Meska and I came to an agreement on all of the settlement. We didn't go through mediation. We just did it on our own.
Okay.
And Mr. Kelly drew up that agreement. And as long as it's the same one from yesterday, we are still in agreement with it.
Oh, okay. Mr. Kelly, tell me, is it the same one as yesterday's, and do we have an agreement?
Yes, we do, Your Honor. It is the same one from yesterday. I've drafted a consent judgment of divorce and the uniform child support order. I just need to get those around for electronic signatures to the parties, but otherwise, we are all set to conclude their case. It was filed on June 22nd. So we're 4 days off from the 6 months. If the court's willing to waive that, we can do the pro-con this afternoon.
Yeah, why don't we do that? Let's set it for the let's do the pro-con. And excuse me one moment. My computer had to be plugged in. It was going out on me. Mr. Kelly, do you wish to examine, or do you want the court to do that?
If there's a preference by the court, I'll defer to the court.
I have no preference, so it doesn't matter.
Ms. Meska, did you cause a complaint for divorce to be filed in this matter?
I think, yes.
You're the
Legal
plaintiff.
language. Yes, I filed.
Okay. Were the statements that you made in that complaint true and accurate at the time?
Yes.
Do they remain true and accurate today?
Yes.
Were you a resident of the county of Calhoun for the 10 days immediately preceding the filing of your complaint?
Yes.
Are you currently pregnant?
No.
Did you have an opportunity to review that document entitled Consent Judgment of Divorce that we've been working on over the weekend?
Yes.
And do you understand its terms?
Yes.
Do you agree to be bound by its terms?
Yes.
Do you feel its terms are fair and equitable?
Yes.
Now, you would have a right to a trial in this matter where you could do the better, the same, or worse as the terms that are contained in that consent judgment of divorce. Despite that knowledge, would you like the court to sign that judgment and enter it once it's received?
Yes, I would.
Do you believe that the bonds of matrimony have broken down such that there remains no reasonable likelihood you can preserve your marriage?
Yes.
Would you like the court to grant you a divorce?
Yes.
I believe that would cover it, Your Honor, unless the court would want me to go into the specific details of the settlement.
No, that'd be fine. Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs in this matter pending receipt of the approved judgment, UCSO, and any other documents. So you're not divorced until I actually sign that, which still may take a couple of weeks because they have to get approved by the front of the court. And then at that particular time, we'll be able to get it entered. So best of luck to both of you. I hope everything works out for you. And the court will end this matter at 1:48 p.m. You're free to go. Have a good day.
Thanks.
Your Honor, could I make one more inquiry? I wasn't sure if Ms. Meska or Mr. Hilderly, he represented her for a moment, have filed with the court a record of divorce or annulment and the judgment information form. Could we find out if that's been done? Because if it hasn't, I'll submit those with our proposed judgment.
Okay, I'll let my staff look that up and see.
Yes, there is one in the file. Yes, the record of divorce form. Yes.
Okay, so then all we need is the judgment and the UCSO.
Your Honor, could I submit that directly to the court, or does that not need to go through front of the court?
You're going to need to get front of the court approval first.
Okay, we'll do that. Thank you,
Okay.
Your Honor.
Thank you. Have a good day.
You too.
You too.
Thank you. Very good.